things that the town board heard was concerns by the people that were not inside the proposed village but outside the proposed village, that they didn't have a chance to vote. That they, one way or another, they were excluded from the process. And so we were asked, as the attorneys for then the village also, what were some of the options that were available under the statutes to remedy that situation. And one of them was what's called an annexation by referendum election. And in that particular type of proceeding, the village publishes a notice of intent and defined the entire remainder of the town as being eligible to be annexed or not, depending what the voters decide, to the village of Bristol to reunify the two bodies, the town and the village. And so we were asked to begin that process, which we did, and we proceeded to a court proceeding, because the court then, you know, you publish your notice and you get a court date and you go and everybody appears, and then the court looks at all the documents, decides if they meet the statutory standards, and if they do, then the court orders an election to let the voters decide whether they want to become part of the village or not. Well, as it turns out, there were errors in the legal description, which, as you might imagine, if you look at the town, is kind of complicated, you know, going back and forth and around, and there were some errors, and we're not going to say that there weren't. They were inadvertent. We didn't think that they were significant enough, but the judge, you know how judges are, they're the judge. So the judge said, you better start over again. And so we were authorized to start over again, and we're right now at the beginning of the start over again process. Okay, so that kind of takes us up to today. Let me talk for a second about the actual procedure that we're in right now. We've already published the second notice of intention to have the annexation referendum. We go to the circuit court to apply for a date for the election, and we can apply between April 2nd and April 17th, April 16th. Then so we file that, then we have our court hearing, the court reviews everything again, and assuming that everything can go okay this time, the court will set a hearing date that's between 42 and 75 days after that date. So, you know, there's a lot of variables, a lot of moving parts. I can't tell you tonight when that hearing date might be, but it would be, you know, just looking logically, probably sometime in the summer, you know, assuming everything goes. We can't, the statutes doesn't say when the court has to have their hearing date, so that's a little bit of a moving target. We had tried to have the referendum election at the same time that the spring general election was going to take place. Save some money, you know, not have too many elections going on at the same time, but you know, sometimes it works and sometimes it doesn't work. So this is pushed out by a few more months. Soon, I'm thinking, you know, June maybe. It kind of depends with the judge, when the judge hears the case, and when the judge asks that the election take place.
Who presents the case?
We will. We'll present the petition.
How many days? Oh, go ahead. How many days after the judge's ruling have you got?
The judge, once we get to the question is how many days after the judge's ruling until the election, and you know, once we file the petition, it's up to the judge to schedule, and that's what I don't know. That's why I'm being vague, because I don't know if he'll do it the next day or the next month or the next week or, you know, whenever that is. But from whatever the date that he hears it and issues the order, they have from 42 to 75 days to schedule the actual election itself. Procedure is rarely used. Most of the time, referenda aren't necessarily the most popular means of doing this. The one case that was cited is about 45 years old and dealt with the town of Mount Pleasant, and I think it was Elmwood Park. And in that case, Elmwood Park, which at that time was really, and I think it probably still is, tiny, was formed out of the town of Mount Pleasant, and the court said, wait a minute, and the town of Mount Pleasant was behind the entire incorporation thing. Here it's a little more equivalent. But it's, and that's why I hesitate, I don't necessarily want to predict the outcome of any litigation on this thing, because it's so rarely invoked. And there are some pros and cons, as most legal arguments would be, but as I say, to me, one of the most powerful things is a referendum of the people, which, indicating their vote, and that would be, to me, a very important piece of information that a judge might want to have before her.